Good morning, Your Honors. Jane Grossman on behalf of Mr. Huffman, the former husband appellant in this case. I would like to reserve 4 minutes for rebuttal, please.
Sure.
Your Honors, the issue we bring before the court this morning, it's actually a pretty narrow issue, a simplistic issue. It's basically the trial court's failure to apply the child support guidelines in a modification action, even though the trial court had found that there had been a substantial change of circumstances in the parties' incomes, basically because the trial court believed that Mr. Huffman was bound by the original mediation agreement, an agreement where the child support exceeded the child support guidelines.
See, the crux of the problem here, at least from my standpoint, is that the substantial change is an increase, which on both sides, which would normally increase amounts. And the only reason it leads to a decrease is that for one reason or another, what I'll call the 50% factor, the shared parental,
yes, sir, Your Honor,
was not implemented in the marital settlement agreement.
Yes. And
what do we do with that?
And before I answer that question, we did have a couple of incidental changes of circumstances. The daycare changed, right. The health insurance for the children changed. So our argument is that it really should not matter in a modification action whether it's the husband's income who changes or the wife's, or whether it's an increase or whether it's a decrease, that if the threshold substantial change of circumstances is met, then 61.30 kicks in. The guidelines must be applied de novo. Because you can imagine the scenarios where if that did not happen and we're constantly second guessing why the child support guidelines were not applied initially in the case, we lose what the guidelines were set forth specifically, and that is uniformity in the application of the parties' incomes to child support.
Roughly a year or so before we begin the modification, these people clearly did not follow the guidelines. It was a substantial deviation from them, and we don't, from this record, really know why, whether that was an accident or whether that was on purpose.
Right, and that's a huge problem.
The 1.540 concept was abandoned in
yes.
this case.
Because, as the attorney stated for the former husband at the trial, Your Honor, we're abandoning that because we feel like we're going to be arguing about something that actually is just going to be resolved in the modification action because we now know there's been a substantial change of circumstances. So the 1.540 basically is moot as far as moving forward on the child support obligation. It might have had some relevance retroactively, but moving forward, because there was a substantial change of circumstances, it was moot. So I would like to point out that the mediation agreement does not contain any language in there to explain why Mr. Huffman was paying $1,500 a month when he had equal time sharing, 50-50. And the guidelines were produced at the trial showing that, in fact, Mr. Huffman's child support for 50-50 time sharing should have been in the neighborhood of $300 or $400 per month.
So, but who should have the burden on the modification as to this omission?
If he were proceeding on the omission, which he did not in this case, I believe it would have been Mr. Huffman. But they didn't even go there. Part of the problem, too, was, Your Honor, once they got to pretrial, the former wife, in her pretrial memo, attached a child support guideline, which included that substantial time sharing adjustment in the modification action. So the parties were going to the final hearing in the modification action under the assumption that this is clearly just a de novo 61.30 application, and not until, as far as I can tell, closing arguments was this whole compromise waiver issue brought up. There was a question posed to the former wife on cross-examination, a very leading question, which is permissible. Mrs. Huffman, was the deviation, the excess child support, based upon a compromise on child support and alimony and things of that nature. Mr. Huffman's trial counsel timely objected on parole evidence. The trial court sustained that objection and said, we're not going to get into that, and they moved on to other matters. Inexplicably, in the final judgment, the trial court makes a finding, and this is what he bases his denial of the modification on. He makes a finding that, oh, you know, I can deviate anyway, regardless of what the guidelines say. I can deviate, and I'm going to deviate because I find that the original amount of the child support was based upon a compromise of the parties as to the issues of attorney's fees, alimony, equitable distribution. And you look at this entire record, there is no such testimony in the record. And we have cited case law that says, that's our second issue, that if the trial court makes a ruling, and that ruling is based upon evidence that's not supported by the substantial evidence in the record, and in this case there is no evidence regarding that, that ruling must be reversed.
Did your client have the burden of proof and persuasion that there had been circumstances warranting a modification?
Yes. And he did that.
I guess what concerns me, looking at this, I've got cases run together, but this woman got like a lump sum, well, a 4-year durational alimony that's not really pursuant to the new statute. It was just what they did.
Yes.
And so that looks
like it was an 11-year
nature of a compromise of some sort, just looking at it.
Well, it was an 11-year marriage, so you have to wonder why she received alimony in the first place. So, but she did receive a specific amount of alimony. It was also, as far as
something happened to the house in this too. He got the house and she got some money or something.
He purchased her interest in the house. They each got their bank accounts. They each got their 401ks, and there's nothing in the mediation agreement which indicates that this was anything other than a 50-50 equitable distribution or a, something unusual about the alimony that she was awarded. I have cited the case of Centino versus Centino, which came out of this court just this year, in which the court held, it was one of my cases, the court held that if there's going to be a waiver of any type of statutory right, in this case, there absolutely is a statutory right to an adjustment to the child support based upon substantial time sharing. That's in 6130.
If in this case, if we continued the no adjustment for child sharing on the recalculation, what would it look like? Do you know?
I'm sorry?
If we continued the assumption of not using the adjustment.
Yes, sir.
The new child guidelines, I would think, would probably require both of them to pay more rather than less.
I think Mr. Huffman, he should have been paying $300 to $400. I think he's going to be paying $400 to $500. It changes on alternating years because of the dependency exemption. And I'd like to point out an argument.
Didn't they have a side agreement on the tax deduction? One child, one boy. One claimed the other child. They agreed to modify it on their own.
Yes, and they were asking the court to incorporate that also. But I'd like to point out, this is not, as the former wife has proposed, this is not a matter of just the former husband's child support being reduced because of the change in incomes. We have to look at the aggregate child support for the children based upon both parties. So the total amount of aggregate child support's never going to change. In fact, in this case, the children's aggregate child support should have increased because both parties' incomes increased by a couple $1,000s a month.
Go back. The nub of this is that at the inception of the divorce, they didn't use the sharing calculation. And what we don't know is, you want to be able to, you could have followed the modification the very next day and say, well, no, we want sharing. And the question is, when it's unclear as to whether they did this on purpose or by accident or what the circumstances in, when is going to be the first time that a trial judge looking at modification is supposed to actually factor in the sharing arrangement?
Well,
isn't that really what the issue is here?
Yes.
And I don't know the answer. So.
Well, I think, well, I'm presuming that I'm going to argue to you that I do know the answer. The burden is not simply that you can apply the guidelines at any time, the day after a divorce or whatever. We know that. We acknowledge that. Mr. Huffman could not have come into court 3 months after the divorce with the parties' incomes being the same and said, Judge, unless it was a 5.40, and said, Judge, I want you to apply the child support guidelines because now they're going to be different. Give me the adjustment. We understand that that could not have happened. The heavier burden, if any, that I think there should be is you have to show that there is an independent substantial change of circumstances other than the child support guidelines. And in this case, clearly, the parties' aggregate incomes increased by $4,000 to $5,000 per month. These children are entitled to a recalculation of their child support based upon that substantial increase. Whether it becomes reallocated when you come down to the math between husband and wife really should be irrelevant.
But the entitlement they're about to get is a decrease in child support, right?
See, I disagree.
Because he's paying $1,500 a month, your client, under the old agreement, and now he's going to be paying $500 a month, right?
Their aggregate child support from both parents, when you consider what they're paying when the children are with them during their 50% of the time, the aggregate child support is staying absolutely the same. Now, if the judge had modified the child support and reallocated, yes, the amount of child support that Mr. Huffman is going to pay, of course, is going to change because he's now getting that adjustment. It's going to go from $1,500 down to approximately $400 or $500. And I pose to the court, what's wrong with that? This man is having the children 50% of the time. The guidelines show that based upon their current incomes, with the statutorily required adjustment to the child support, he should only be paying $400 or $500 per month, having the children 50% of the time. To find otherwise, Your Honor, is to say, you know what, Mr. Huffman, for whatever reason, agreed to $1,500 per month child support. So long as his income never decreases, he is bound by this child support for the entire minority of the children. That is patently unfair, and that's what this judge found.
Let me ask this.
Go ahead.
This petition for modification was filed 11 months after the final judgment, if I recall correctly. And the trial court did, in fact, as you say, found this to be a change in circumstantials. The trial court used the word substantial, but apparently did not use the word material change in circumstances, and I wonder if that's based on the fact that the testimony before the trial judge from Mr. Huffman was, my salary is entirely on commissions. It's not stable. It can go up. In fact, in 1 year, he had more than he thought he made, I believe the transcript shows. And hers is a combination of salary and commission. So in 11 months, perhaps the trial court is not able to ascertain that because their incomes are based on commission, this is a trend that's going to continue.
I don't believe so, because I think the testimony was Mr. Huffman's compensation package was the same 11 months, not the dollar amount, but the makeup. His package was
about the same, but he also indicated, I think, that he sold a particular device of medical equipment that allowed him to get a boost up in his earnings that in years gone to in the future he was not anticipating.
Yes, sir.
So I'm wondering, the trial courts are sitting there saying, this is 11 months over. Right now we have a trending upward. She's gotten a raise, I think she said either June or July, that her salary went up, and I think even the cost of her, what do they call that when they reimburse you for the use of your cell phone and your card, the allowances.
Right, the in-kind reimbursement.
So, but there was, after 11 months, it's difficult to determine whether this is going to be a material change that's going to exist, or as Mr. Huffman testified, my income could go down.
Well, yes, the judge did not make a finding that it was material. I don't know whether it was why he did or did not, but the point is, at the time of the final hearing, we were not 11 months out. We were, if you looked at the date of the petition and the financial affidavit of Mr. Huffman, he actually had a decrease in his income. By the time they got to trial, which was 2 years later after the date of filing, we have a 2-year history of husband and wife, so it's not just 11 months. And clearly, I think with a 2-year history, we can even, at this point, find that there is a material change of circumstances. But I have cited some case law to the court the Cyberlick case, which I think is relevant, not because of the fact that the husband's income had decreased and in the husband, in our case, his income had increased. Obviously, that's a difference. But the commonality there is the fathers in these cases have showed that there was a substantial change in their incomes. The second prong in the analysis in the Cyberlick case was originally Mr. Cyberlick did not get an adjustment for the substantial time sharing. He had 45% of time sharing, and for whatever reason, he too was not given the adjustment. The trial court reduced his income because his child support because of a reduction in income, but said basically, no, I'm not giving you the adjustment for the time sharing because it wasn't in the original agreement. And that was reversed on appeal. The appellate court from the 4th District said no. Once you have a substantial change of circumstances, the application of 6130 is mandatory, and the trial court is required to make the adjustment for substantial time sharing. And I'd like to point out to the court something interesting in 6130 that I was not aware of really till I immersed myself in this case, and that is 6130 talks about it must be applied in an original and a modification action, and it talks about the trial court can deviate plus or minus 5% more with written findings. It then concludes with the sentence, notwithstanding any variance options available to the trial court, comma, the trial court must apply the substantial time sharing adjustment. My reading of that is do the plus or minus 5%, do anything you want, but the substantial time sharing adjustment is mandatory.
But the statute's not written in contemplation of the strange marital settlement agreement that we end up here with.
No.
You know, just thinking aloud, I mean, maybe the rule should be that the wife is not entitled to get any increase in child support on a substantial change in circumstances until the calculations under the statute would make him pay more than $1,500. And he's not entitled to a change unless he can show a substantial change that's a decrease in his income as compared to an increase in this.
I'm envisioning a horrible can of worms because I'm also envisioning a situation like the Knight case where the husband actually had an increase of his income of $450 a year. Okay, so we have to think about a situation where what if Mr. Huffman came into court, he had an increase in his annual income of $1,000 a year, but Mrs. Huffman had her $3,000 or $4,000 per month increase. So what are we going to do in that situation? Are we going to have a hyper analysis of father's income over here, and then we can and cannot do A through G, and then the wife? I think the threshold burden has got to be simply substantial change of circumstances, threshold, and then a de novo application of the guidelines and the mandatory application of the adjustment for time sharing. And I would like to point out, I know I'm running out of time, I would like to point out that this agreement, clearly the Wetherington case from Georgia talks about this, that just because you agree to a higher amount, we don't concede that he did agree to that, but if you do agree to a higher amount of child support than the guidelines, that is in no way a waiver of a future right to modify. You're not bound by that. And in this case, the mediation agreement has a requirement that each and every year these people are going to exchange financial affidavits, so clearly they contemplated
something. Yeah.
Yes.
Okay, I'm going to save you 2 minutes for rebuttal.
Thank you, sir.
May it please the court, Michael Park on behalf of the former wife, Rebecca Huffman. As I've stated in my brief, I think we're kind of getting far afield of really the crux of this issue. And that is, what I'm hearing in argument from the appellant is you didn't apply 6130, you didn't do the mathematical calculation, you did it wrong, you didn't give him an adjustment for substantial time sharing. But before you get there, you still have to hit the threshold of meeting your heavier burden to qualify for modification. And I think that's where this case really turns. What Judge Minkoff said in this case was that I looked at all the circumstances, I looked at the change, and the substantial change was, he didn't say a substantial change which was permanent, involuntary, the 4 prongs that we need to find, not contemplated at the time of the entry of the child support amount. He didn't find any of that. He just said, I find that there has been a substantial increase in income. And getting to Judge Casanueva's point, he didn't make any findings whether it was permanent, material, or any of those things. He just said, yeah, incomes have gone up. That's clear. Both parties admit that. But the threshold question really is, has the husband met his heavier burden to prove that he gets a modification? And you can't use the guideline that say...
Hasn't the statute been amended so when there's a 5% change or so under the new information calculated annually that this is almost automatic?
Well, it is changed to that, but you still have under...
It's not some substantial, unexpected kind of thing. They just annually go through and they can recalculate this, right?
Based on the statute or based on the mediation agreement?
Based on the statute.
Right, if there's been but you still have to prove that it's been a material change. You've still got to hit the threshold. Just because you come in with a new child support guidelines worksheet...
But isn't a 5% change in income by statute deemed material these days? I could be
yes, but you still don't have unanticipated, involuntary, and not contemplated. Well, that's unanticipated. But there's more than just that one prong in order to...
The statute says that 5% has to be unanticipated and all of those things. Just
yes, sir.
Changes in the economy don't allow for changes in child support now?
Well, if it's material and involuntary and you meet the rest of the prongs of making it a substantial change, then yes, you can adjust child support, and you need to adjust child support. I wholeheartedly agree with that. The problem is you still have to cross the threshold of meeting those requirements, and I think that's where we get hung up in this case is the court didn't find that there is a need to modify the child support. I don't know why I'm ringing here. But it found that the former husband didn't meet the threshold to even do that calculation. So we're kind of putting the cart before the horse, to borrow a term from my predecessor who was up here not too long ago. They're arguing the judge should have applied the guidelines and applied the substantial change of circumstances. The court didn't even get that far. The court basically said, we don't have, the husband failed to meet his heavier burden. And I think what case law consistently says is what we really need to protect are the minor children. And that's really what child support is. Child support is the children's, not the parents. And we'll protect the children before we protect the parents. And what has really functionally happened in this case is the gentleman who agreed by mediation in an agreement that was mediated on July 12th, which was entered and signed by him 3 days later. He had 3 days to think about it, 3 days to ask his attorney questions, 3 days to do whatever he wanted to do, still signed it. He admits in his deposition testimony and at trial that he was not under duress. He knew what he was getting himself into.
Does the agreement say that I had the impression the agreement said that this amount was under the guidelines, or pursuant to the guidelines or the law?
I don't recall that from the agreement, Your Honor. It could be there. I just don't have that.
Well, it's sort of important because it isn't by the guidelines, and there's nothing in the agreement, as I understand it, to say that the parties were intentionally deviating from the guidelines, or that the problem here is that this isn't in accordance with the guidelines, and there's nothing in the agreement itself to help us sort out what to do with that.
No, but well, there's the former wife's testimony, and I understand Ms. Grossman's point about when they started to get into it, there was objections, everything else, but the bottom line is the former wife on 3 pages of testimony, I think it's record or transcript 102 to 105, did state, yes, I gave up valuable options and valuable rights under this agreement in order to get this, in order for this entire agreement, to fashion this whole agreement, including the child support amount. And that's really what the judge based his conclusion on. Now, when Ms. Huffman started to talk about that based upon the law which says you don't get into mediation discussions, it stopped there. But the overarching question was asked and answered specifically by trial counsel. Did you give up valuable rights in order to get this agreement the way it is, including the child support? And the answer was yes. And that was unrebutted by the former husband. He didn't come back and say, no, that's not true or anything else. So her testimony is, I gave up rights to get this amount.
But she didn't get any agreement in, there's nothing in the agreement to say how that affects modifications down the road. And
No, there's
if
not.
they're exchanging financial information every year, that would be indication that they were contemplating that modification would be pursuant to statute.
Well, I don't know that I'd go that far. That was an indication that they contemplated in the future it may be modified. I wouldn't say that they were contemplating it be modified by statute. I think that's speculating a bit.
How does the trial judge override the statutory structure if the agreement doesn't expressly do that?
The trial court has discretion in this area. If you look back at the case law, you look at, Finley versus Scott, which is a 1998 Supreme Court case. You go back and you look, and that was an interesting case. The guidelines provided for $10,000 in support. The trial court came back and said, I don't need to give you $10,000, I'm going to give you $5,000, and $3,000 of it is going into a trust because mom was only actually using $2,000 of it. So to say that the guidelines are the end all for making these calculations is inaccurate. The trial court does have discretion to do equity between the parties, and if we have a situation where you have a good fortune award like that, where there's just excess amount that only gets spent on mom and not on the child, the court can reduce that. And it's also interesting to note that I believe 6130 says these guidelines are presumptive. I think that's in the first sentence. This is presumptively what is to take place. The court always had the ability to do what's equitable between the parties. And if you look at really what's designed, child support's designed for, case law is clear. It's for the child. And if you look at what would have happened if the trial court agreed with the former husband in this case, you've got a guy paying $1,500 a month. This is what the kids get. His own financial affidavit shows that he has a surplus of $3,000 a month. He now wants the court to modify and decrease his child support based on an increase to $153 a month. That's what he was seeking, $153 a month. And to say that somehow the child is going to get more money is just not logical. Now, I understand the academic argument there, but practically it's not true. And the court looked at this and said, hey, listen, there is a reason why we still have on the books, you have to meet a heavier burden. We know that the statute says it's the same across the board, but then you have Typtig versus Boggs and all his progeny, which says, yeah, that's true, but for a mediated agreement and only when it's a decrease being sought in child support, not an increase. And you look at the public policy there, the Supreme Court made it pretty clear. The reason why you do that is you don't want to have the kids getting thrown under the bus having less child support. So intrinsic in that analysis in Typtig versus Boggs and the rest of these cases is the fact that the court does need to look at the impact on the children. And it is a factor that is absolutely paramount to determine whether or not this heavier burden has been met. And if you look at what the trial court said in its judgment, it said, looking at all these factors, I'm going to find that he didn't meet the heavier burden. It's 11 months post-judgment. He tried a 1.540 motion saying, hey, it was my mistake. I think it needs to be a mutual mistake under that statute. He later abandoned it because of deposition testimony, which proved what his basis was not accurate. So he abandons that and moves forward on the substantial change of circumstances. 1.540 motion was the right way to attack this based upon the way he tried to attack it. He abandoned that. That was his own election. And now he's moving forward. The court made the threshold decision. You don't meet the heavier standard here. That's not to say in the future that might not change. He can, if his income goes down, if there comes a point in the future where there's a basis for a modification and the court finds he meets his heavier burden, then it will be modified. This isn't an absolute bar to modification.
What happens if, by great fortune, your client gets a new job tomorrow that doubles her salary?
Well, then I think that's a much different situation, because then you look at what the capability of the mom has to provide child support for the minor child. There's a lot more money.
I haven't done the math, but what I'm betting if you go by the guidelines, his amount will go down.
It may go down, but the problem here is you've got to look at what transpired here and look at the kids and say, okay, what do they get out of this? And first of all, there's 4 years of my client getting $1,800. That's fixing to run out in 11 months. So there is going to be a change where her income is going to go down, which is going to materially affect the children because she won't have that money for support based on the appellant's argument here. But I think getting to your point, if you have a scenario where her income increases substantially and there is enough income there to where the kids are not going to be hurt, that's a completely different story. Her income went up by like $1,500 or something like that. And she was still paying, obviously, when the kids are with her, for all the goods and services necessary for the rearing of 2 children. And he's paying $1,500. The bottom line here is you're being asked to infer a negative from an agreement which doesn't say anything about it. You must infer that there was no provision for a deviation from child support. You must infer all these different things. And the fact of the matter is the mediated agreement says $1,500 a month. The rule of Florida is parties are free to contract whatever they want unless it's violating public policy or illegal. But you're adults, you can contract for it, and we're not going to get you out just because it's a bad bargain. So he has to prove that he met that heavier burden, and the trial court said it didn't. Now, moving on a little bit, the court goes on and says, even if he did, on the substantial change of circumstances, I'm going to find that I would deviate based on the best interest of the children, effectively, because I'm going to find that $1,500, you remove all this child support. I don't think that's right. And I would basically make findings of fact to deviate and keep it at what it is, which is getting back to my argument that the trial court properly looked at the impact to the minor children and said, I don't think reducing support from $1,500 to $150 is in the child's best interest. Therefore, I'm not going to do it. And if you look, tipsy coachman doctrine, even if the court did the right thing for the wrong reason, it still stands on appeal. Getting to one of the initial things, the appellant and I have a difference of opinion on what the standard of review is here. It's always an interesting intellectual exercise. They're claiming it's de novo. I think it's abuse of discretion, and I think what we're arguing over is their position is you didn't apply the statute, therefore it's de novo review. And I would agree if the court, in the case they cited, I forget the name of it, was basically a situation where the court didn't do a deduction from a gross income and it was a mathematical problem and an error. I wholeheartedly agree, that's a de novo review. In this case, it was a finding of fact about failing to meet a heavier burden. That's abuse of discretion. And even the case that they cited, the first line in the opinion is, with regard to child support in this issue, ordinarily this is abuse of discretion. Ordinarily this is up to the discretion of the trial court. So I think that colors this whole argument, because the difference is it deference to the trial court? You got to look at whether any reasonable person could have done what the trial court did, or do you guys sit here fresh in a de novo review? And I argue that since this is a finding of fact, since this is a threshold question of failing to meet the heavier burden, that is a deferential finding of fact that you must look at and say, okay, well, could anybody have done this? And the answer is yes, looking at the impact of the minor children, which I think is a valid thing. The second issue, obviously, they've asked for de novo review. I still think that that's a substantial competent evidence, as I stated in my brief. The question they've raised is whether or not what the court found with regard to giving up valuable other assets and such in the immediate agreement is something that you look at from a de novo standpoint. I say it's substantial competent evidence, and I suggest that the evidence is in the record based on my client's testimony that she did, in fact, it was unrebutted, she did, in fact, give up valuable other things in order to get the entirety of this argument. And for that, I believe that this court should affirm the lower court's denial of the modification. Unless there's any other questions, I guess I'm done.
You have a fee motion, or it is?
I would have to look. I would imagine.
Yes.
I would imagine in this case I would, but so I'll take her word for it. Yes, sir.
Our position is that we remand this for just a determination of both entitlement and need.
A RADOS remand. Yes, sir.
A standard RADOS order. Is there any reason why we shouldn't do a standard RADOS order in this case?
No, sir. I don't believe so. RADOS would be applicable.
Thank you.
Thank you.
Ms. Grossman, let me ask you that same question right up front. Is the fee motion supposed to be handled with a standard RADOS order in this thing?
Well, the court does always have the discretion just to deny the request.
Right. Just asking what you want me to do.
That would be our first position. But, Your Honors, seriously, in this case, the parties' aggregate incomes increased by $4,000 to $5,000 per month. That clearly is a substantial change of circumstances. 6130 says that when that happens, you must apply the guidelines. There can be a variance based upon lifestyle and things of that nature, but that doesn't apply here because the judge's whole reason for deviating, he said there was a compromise. He didn't say anything else. He said, I'm going to deviate because there was a compromise.
6113 makes this a mandatory modification, is your position?
I'm sorry?
6113 makes this a mandatory modification when the numbers are...
Yes, 6130 says when...
Is it 30 or 13?
30.
30, okay.
But in this case, there is no waiver in this agreement, and even if there were a waiver, I would suggest that that would be void against public policy. Parties cannot ever waive the right to modify the child support. That belongs to...
Even if it modifies downwards as compared to upwards, because we have improved economic conditions resulting in a decrease in child support, right?
Yes.
And that's certainly... The public policy is to protect the children, which, I mean, if we were shortchanging them on an increase, I would see that, but...
Yes, and I wish we had time so that I could further debate that with you, because I see that you're struggling with that, but we can't look at child support as just what husband pays and what wife pays. We have to look at the aggregate amount that's ordered, and then you look at the allocation between the parties. So in this case, when you have a $4,000 or $5,000 per month increase in the parents' incomes, these children are by law entitled to have their child support recalculated.
Because the aggregate amount will be more than the combined total of his $1,500 and I don't know what.
Yes. Yes. So you look at the aggregate substantial increase, then you apply the guidelines, and then you get to the allocation.
Before the modification was filed, what was the aggregate amount the two children were receiving from both parents?
I had that figure for you in case you asked. I believe it was $2,400 because the wife's share was $918. The husband's was $1,504 without the adjustment. And then in the modification action, the wife's child support would increase to $1,400 per month, and the husband's would be $2,400 without the adjustment. So the children's child support should have increased by at least $1,500 per month, and they were denied that because the trial court did not modify.
Those are the numbers. How did the net go down to only $150 a month payment by the husband?
Well, that's after the substantial time sharing adjustment.
Oh, okay.
The figures I gave you are what would they pay before any adjustments, because I was comparing apples to apples.
Okay, okay.
Okay? We didn't touch on, Your Honor, this heavier burden that is still actually good case law where if people agree to a child support amount, they have a heavier burden of modification than if the child support's court imposed. That was addressed in the Tetic case. Justice Overton disagreed with that. We would disagree with that because it absolutely makes no sense in this case for the trial judge to have said simply as a reason for his ruling, oh, and by the way, because these parties agreed to child support, there's a much heavier burden, and this burden wasn't met. It makes absolutely no sense for there to be the disparity in the burdens of proof.
Okay.
Thank you.
Okay, thank you. Of course, we're going to take about a 10-minute break, and when we come back, we'll pick up with Woodfield Community versus HSBC Bank.